Good morning, everyone. Today is Monday, April 13th, 2020. It's approximately 10 a.m. Pacific Standard Time. We are joined once again by the Family Law Matters legal panel. And today we want to talk about defending against a restraining order that was issued. I do want to remind the participants as you join in, please make sure that you are muted. I will go ahead and mute all the participants that have just joined. There we go. Okay, so again, if you have any questions, please make sure that you send them to us in the chat or raise your hand. We'll get to them. Otherwise, feel free to email them to us and we'll get them addressed. Again, the focus of today's podcast is defending against a domestic violence restraining order that's been granted against you. So I want to start by giving our legal panel an opportunity to introduce themselves. And I'm going to start with you, Gina.
Hi, I'm Gina Famularo, and I am a partner at Family Law Matters. I've been here for 22 years, and I've only practiced family law my entire career.
Thank you, Gina. Colleen?
Good morning, everyone. My name is Colleen Robinson. I'm a family law attorney here at Family Law Matters. I've been practicing now for 10 years in San Diego County and Riverside County, as well as appearing throughout Southern California.
Thank you, Colleen. Christy?
Good morning, everyone. My name is Christy Bergamo. I'm a senior attorney here at Family Law Matters. I've been practicing 17 years and exclusively in family law. I am also an instructor at the University of California at Riverside for their paralegal program, and I've been certified to be minors counsel in courts in California.
Thank you, Christy. And I am Bishoy Shahada. I am a managing partner at Family Law Matters. I've been an attorney for a little over 2.5 years. And family law is all I know. So let's get to it. Gina, I want to start with you. Our last podcast talked about domestic violence in general and what qualifies or what needs to happen in order for you to seek that type of protection. Today, I want to focus on the opposite. So what advice would you give to someone who was served with a restraining order? Why should they care?
That's a great question, Bishoy. A restraining order is a very serious matter. It is what we call in law quasi-criminal. That means that even though it's filed in the civil courts, it does have criminal penalties attached to it. For instance, someone can go to jail for violating it. Another reason why people should care if they received a restraining order is because there's consequences attached to it. And we go over those pretty thoroughly in our last video. Things like you could lose your job, can't own a gun, you cannot pass a security clearance. There's various things attached, including losing custody of a child, perhaps even a child not related to the child of the parties.
So what happens if it's granted?
Sure.
Do that.
Sure. If a restraining order is granted, there's going to be an order. So a domestic violence restraining order will have an order after hearing. And in the order, it will specifically say what the restrained party can and cannot do. For instance, some restraining orders talk about how you can still have contact, but there's no negative contact. Other restraining orders bar all communication. Some prevent the parties from being within so far of each other. Other ones, if you can believe it, kick someone out of the house. So it's very important that if you get a restraining order, you immediately call an attorney and you have them help you review the orders and go through them so you know what you can and cannot do.
And when something like that is filed with the court, how do I know about it?
Well, you're supposed to be served, Bishoy. That always doesn't happen. You're really not going to know unless you show up at someone's house and the police are called and they notify you. Or the way it's supposed to work is you're supposed to be handed what we call personally served documents by the person who's requesting the restraining order.
Now, is it by the person themselves or is it by someone else?
Well, as you know, it would be by anybody over the age of 18 other than the restrained party. However, sometimes it's not always done properly.
Okay. And I'm sorry, I do want to clarify because you said other than the restrained party. You mean the party seeking the restraining order, not the party restrained?
Thank you for clarifying that. Yes, so the protected party is what we call them.
Okay.
Someone other than the protected party who's an adult is supposed to be the one serving the restraining order.
And what if I am not served properly? What if that doesn't take place? Can I just ignore it?
Well, I think the takeaway from this video will be that a restraining order is an incredibly serious matter, that if you are being accused of domestic violence, that you should not ignore the process. You should always participate in the process, no matter what the facts are, no matter if you think it's a valid restraining order, no matter if you care whether or not you see the person before or again, no matter if you think that you've been served properly. If you have any hint that a restraining order has been filed against you, you need to immediately pick up the phone and call counsel.
Perfect. Thank you, Gina. And Colleen, I want to bring you in about and talk about the process. So
Okay.
What is the process to dispute and defend against a restraining order that's been issued against me?
Well, so the process to dispute is your hearing. So on your copy of the temporary restraining order that's served upon you, on that first page is going to indicate when your hearing date is. That's the day you fight the temporary restraining order, or you're fighting the grounds for why it was granted, not only why it was granted, but why it shouldn't be granted on a permanent basis. So you need to prepare for that hearing. It's issued, that date is given 21 days when the protected party filed for the request for the temporary restraining order. So it's a very short order.
And between the day I'm served and the hearing that's coming up within 21 days, do I have to follow the orders that are in those documents?
A really good question. And the answer is yes, because that is a court order. So it'll say you should be getting a copy of the request for the temporary restraining order, and then also the temporary restraining order itself. What you need to pay attention to is the temporary restraining order itself, because that is now a court order. And you'll need to, and as Gina indicated, there could be custody orders, there's personal conduct orders that are listed there, whether or not you're going to get kicked out of your own home, vehicles, debt payment, whole kinds of things. So you need to make sure that you read it very carefully. And Gina had suggested in it, and that's all of our recommendations here as well, is that the stakes are too high for you to make a mistake, and for you to contact an attorney to review what is expected of you until your hearing date.
So I'm struggling a little bit with following the temporary orders, just for the fact that what if the restraining order is based on lies? Do I still need to follow those restraints?
That's a really good question, and unfortunately the answer is yes. So even if you know in your heart of hearts that declaration that was submitted to the judge is incorrect, it's like blatantly lying, like that didn't even happen. I have 500 witnesses that are going to testify to the exact opposite of what occurred. Until your hearing date, you have to follow those court orders, because that's what's going to get enforced. That's all that the court is aware of. That's all the court has right now. And that's all that the sheriff's department or the police department are going to have. So if you violate that temporary restraining order, you can get arrested. And that's just something that you cannot play around with. You have to take it seriously, even though you believe that it's all fabricated, it's not true. Until your hearing date, you have to follow those temporary restraining orders.
And what happens if I don't follow, just to be very specific with the viewers here, what happens if I choose not to follow those temporary orders? What's my liability?
So let's just say that you've been served with the temporary restraining order. That includes you have to stay 100 yards away from the protected party. And you decide, and there's also person contact, like that you're not to contact the other party either. So let's say that you decide to show up at the house because it's your house. Whatever, it's my house. She calls or he calls, the protected party calls the police show up. They have in their system, through the collect order, already a copy of the restraining order, or the protected party gives them a copy of the restraining order and a proof of service. You're going to get arrested for violating those court orders. You just have to assume you will be arrested for violating court orders. And now you've got an even bigger dilemma on your hands, because now you're going to have not only the family law restraining order hearing, but now you could potentially have a criminal hearing or a criminal case opened up as well. So it's something to be taken very seriously, even though you do not believe that the facts and why the temporary was granted are incorrect. You just have to take them seriously. You need to follow those temporary restraining orders and assume if you violate them in any way that the police are going to get involved and you could potentially be arrested.
And Colleen, will my violations of the temporary orders, or I'm sorry, let me rephrase, can my violations of the temporary order impact or negatively impact the hearing?
It can, yes, in a variety of ways. One, that then if there's a criminal hearing that's pending or a criminal case that's pending, that could delay your family law hearing, for one. But also it's going to, if you have violations of the temporary restraining order, you can guarantee that's going to be brought up, that you cannot follow a court order, that you do not respect the court order. And now you're fighting that as well. Not only just the facts of the temporary restraining or why the temporary restraining order was granted, but now you've got this whole other issue you're going to have to deal with the judge as to why you're violating his or her court orders.
Okay, so now thank you for that. I want to shift a little bit to some technicalities, as I call them. So what if we both work at the same workplace? Let's say Amazon, for example, and I was served with a restraining order, but we both work on the same platform. What do I do then?
That's tough, and that's certainly happened, and I've had that happen with my clients, that they work in the same place. And my advice is, again, you don't want to be in a situation where you violate a restraining order. So that is a conversation you need to have with your HR department right away, and show them a copy of the restraining order. And I can't be around this person. I'm trying to be proactive here. I don't want to get in trouble. What can I do, or what arrangements can be made so that I'm not around this person at all? And my experience is that HR worked with these people to prevent them from working in the same floor, the same area, or whatever, to try to comply with the court order.
Okay, and what about if the other party, the protected party, keeps contacting me after I've been served with the temporary restraining order? What do I do?
So ironically, that does happen quite frequently, is to document that. So do not engage. You are the restrained party. You are not supposed to be contacting that other party. But the protected party is not the one with the orders against them. But it is going to, what I want to say is that them contacting you after a temporary restraining order has been issued is certainly going to play at your hearing. So if they're contacting you, make sure you document it. You know, like if it's text messaging, your phone calls, you're screenshotting, or whatever, you're not engaging, you're documenting. Because it's going to go to the core as to why this person is still contacting you. If they're fearful of you, they're engaging with you for whatever reason, that's going to be evidence to use at your restraining order trial.
So if I understand you correctly, even if the other party is texting, I should not respond.
My play it safe. You do not respond. Do not engage.
Okay.
And you don't have to say there's a restraining order. I'm not contacting you. Just do not engage with that other party. You do not want to be ensnared into a situation where you're violating the restraining order. So you have to protect yourself. You have a quasi-criminal restraining order issued against you. Do not engage and wait and just collect that information, collect the evidence, give it to your attorney so that we have that at your restraining order hearing.
So if I understand you correctly, if the protected party makes contact, they are not in violation of the restraining order, even though it can be used against them at the hearing, but my responding can be used against me, and that's a violation of the restraining order.
That's exactly right. They're not the restrained party. They're not the ones with orders against them dictating how they can interact with the other party. You do. So you cannot engage, even though they may entice you to, like, oh, we can work this out, I'm sorry, whatever. There's still a restraining order in place. And so again, you do not want to put yourself in a situation where you're violating a restraining order. Now they call the DA's office or whatever, they've called the police, they can make a report, and then you're going into your your hearing with violating the restraining order. So that information, again, them in contacting you can and should be used at your restraining order hearing.
Perfect, thank you. And then I want to talk about situations where children are involved. So if the protected party files for a restraining order, the children are included on that restraining order, but the children continue to contact the restrained party. As the restrained party, should I respond to the children?
I would not, because again, they're included on the restraining order. There's orders specific, if there's orders specifically about no contact and no visitation until your hearing, which is a pretty common order involving when custody is involved on a restraining order, you should not engage, do not contact. And I know how hard that is to, when your children are reaching out to you, but you have to protect yourself, and you don't want to be placed in a position where you're harming yourself when it comes time to your restraining order trial.
So I'm sorry, that's difficult. I can understand as a parent that's gotta hurt. But let's stay on track. So with the temporary granted, do I risk losing my job with the temporary being granted until the hearing?
No, well, so as we talked about in our previous podcast discussing restraining orders, kind of from the other perspective of a protected party, a temporary restraining order does not appear on a background check. So and if you think about it as what Gina was talking about in her discussion, is that the idea is that you didn't have a chance to present your side of the case. So there's no permanent effects like that of losing your job. A permanent restraining order, certainly you could lose your job. It'll show up on a background check. It'll show up for your security clearance when they start going into that. Firearms, those kinds of things. That could absolutely impact your ability to keep your job and to obtain a job in those areas. But a permanent restraining order does not appear on a background check in that way.
Perfect. Thank you, Colleen. Christy, I want to bring you in on this conversation from a litigation perspective. What is the key difference between a temporary restraining order and a permanent restraining order?
Well, I think Colleen said it best when she said that basically on the temporary restraining order, I think a lot of the issues from clients who've been served this information is that I wasn't there, I wasn't aware of this paperwork being filed, I didn't get an opportunity to respond. And so the information that's given on the restraining order to the court, basically the judge unilaterally, which means like just with that information, decides whether or not to grant a temporary order. And that's what both Colleen and Gina have discussed. So then you get a court date that's 21 days out, and you'll see it on there, it's on the face page, and that's the hearing for the permanent restraining order, which is, again, why you need to contact an attorney, why you need to be prepared, because it does come rather quickly, because these are very severe orders in the meanwhile, as we've discussed. So that's going to be your hearing for the permanent.
And Christy, what happens if I am not ready as the restrained party? What happens if I was served and I didn't have enough time to contact an attorney? What can I do at this point?
Well, I think there's a few different scenarios be in that situation. Number one, I got the paperwork yesterday or the day before. On the temporary restraining order, you have a statutory, which means the judge puts on the paperwork how many days in advance you need to be served. So again, it's just all the more reason to reach out to an attorney, have them review this stuff, because we'll know what to look for. So say you get it, and it's usually 5 days beforehand. So say you got it yesterday and your hearing's the next day. You have a right to go in and request a continuance. But the problem with that is that, you have all these orders against you. If in fact you need that continuance, then those orders are going to remain. So, you really have to be careful with those types of issues. And again, that's all strategy that we can certainly help you with. So that's the first scenario. The second scenario is you were served in the amount of time required. So it's usually like 5 days beforehand. So you were served in plenty of time, you were served properly, but you're just not ready. You're still gathering your information. Again, you have a right to a continuance under both scenarios. And those are, like I said, statutory. One's a timing issue, so you may get another continuance if you wanted, but the other one is because you're just not ready. So again, there are all these very tricky nuances to this process that we are familiar with. So you really need to discuss these issues with an attorney.
Thank you, Christy. And what if the other side, the protected party, is the party that needs a continuance?
My experience is that 99.9% of the time, unless it's a really good reason, like they're in the hospital, they are not afforded that same luxury, because you, as Colleen aptly pointed out, you have a due process right. You have a right to have this matter heard very quickly because of the level of draconian orders that are made, the level of harshness of these orders that apply to you, like being kicked out of your home, not seeing your children, not being able to work around your, the restrained party. I mean, conduct orders that limit you. So because of those reasons, if they file, usually, almost 99.9% of the time, they have to go forward. They don't have the same right you do.
And Christy, if the cops were called and the restrained party was arrested, what happens now? How does that impact the current civil case?
It impacts it quite significantly, because now you have two matters going on. You have your civil restraining order matter where the protected party is seeking relief, but you also have a criminal case. And a criminal case is significant because you have a right to remain silent. That means that you have a right not to incriminate yourself in any other proceedings. So it's going to be very difficult, and you're probably going to be advised against it by your criminal attorney, by me, by the judge, not to say anything with respect to this matter, because like I said, it could be used against you in the criminal matter. And if you have any inconsistencies, that's where it starts to possibly build a case against you in the criminal matter. Usually we can ask for a continuance so that we can see how the criminal case plays out, but it is a significant consideration, and it's really a case-by-case basis. Sometimes it takes a while for the prosecutor to file anything. So you're in this limbo mode, and you don't know if they're going to do that. So these are things that we are all very, very familiar with. And I don't want to answer that blanketly, because it is a case-by-case basis, but it could affect your ability to testify in your restraining order matter. I feel at that juncture, and if this is something that's not going to be sorted out, the judge in the civil case, this restraining order case, is not going to wait forever till your criminal case gets decided. So I think as far as that's concerned, you need a really, really darn good lawyer to be able to defend you against a restraining order without you having or being able to say anything. So again, this is not something to mess around with. This is something that you absolutely need help with.
Thank you, Christy. And then what about an outstanding warrant? How does that affect the civil case?
Usually in civil courtrooms, they are supposed to run the record of every person that is in attendance in the audience to see if there are any outstanding warrants. So that's a conversation between myself and my client. Like, look, you just turn yourself in. Do you appear the first time and get that sorted out? I mean, that's, again, there's no hard and fast rule about what I would advise a client to do. It would just really matter on the circumstances, i.e. how severe the warrant is. I mean, is this something that's, requiring a huge bail or not? So the questions are endless in that regard.
So with that, then all of these permutations and all of these different ways that the case can play out, what, as the restrained party, what would you suggest I start gathering in terms of evidence?
Well, obviously, as Colleen pointed out, there is a declaration. So there's something that the court has read to base their issuance of a restraining order. So obviously, number one, it's reviewing that declaration to see if you have any information to dispute it, either through witnesses, either through documentary evidence, text messages, emails, Facebook posts. I mean, all of that stuff is very relevant. And then I get the situation a lot where I'm not the aggressor here, they are. You know, this is not correct because I'm the one usually, you know, defending myself. Well, then obviously you would want to get all that information, you know, witnesses that see them being the aggressor and things of that nature. So it would be just everything, and I call it the kitchen sink. Give me the everything in the kitchen sink, and let me as your attorney parse out what I'm going to decide is relevant to your matter, that's on point. But the more the better. I mean, you know, the sky's the limit on what it is that you need to gather, because what starts to happen is if someone came in on a restraining order and it's based not in fact whatsoever, there's nothing true about it, I think usually there's children involved, I think that's going to play out in other areas of your case, i.e. for custody, visitation. If someone's made a false claim about domestic violence and things of that nature, I think it's going to have a very significant effect on your other aspects of your case.
Thank you, Christy. And with that said, for final comments, what's the best advice that you would give a party who's had a restraining order issued against them?
Well, I think I need to say one more thing before I conclude with that, B, is that a permanent restraining order, I think people think it's forever and ever and ever. It's not, number one. Number two, it can be issued up to 5 years, okay? So think about that. For 5 years, you could have orders in place that would limit your ability to see your children. Presumptions apply that you should not have legal or physical custody of your children. It could, like we talked about, have influence on your work. It could get you fired. It could prevent you from not getting a job. And that's just the beginning. You're restrained in terms of your conduct. I've had cases where, you know, the children are involved in sports and my client was the coach, and now they have this restraining order against them and they can't coach their children in their sports. And these are huge and damaging ramifications. So my advice is you need an attorney to defend you in this. You need to be prepared, you need to have a strategy, and you need to defend yourself vigorously against these claims. This is not something that you say, oh, you know what, I don't even want to see this person anymore anyway, I don't care. You do care. There's not one aspect of this entire proceeding that you should not care about. And it doesn't matter if you don't have any children together, you don't work at that job anymore, because this thing looms and it's there for, like I said, up to 5 years. So you need to contact an attorney. It's the best money you ever spend, because if you don't, then like I said, the ramifications are debilitating, to say the least.
Thank you, Christy. Colleen, would you like to add anything?
I was just going to say, even talking, one of the other things too about strategizing is that we can determine what witnesses are needed and if we need to issue subpoenas to any other witnesses, and like police officers, for example, that came to the call. Sometimes they have conflicting information that's very relevant that a judge would want to hear. Or you have somebody maybe who isn't your friend that we need to subpoena. These are all conversations you need to have with an attorney to determine what we need and who we need as well, not just the physical evidence, but the in-person testimony that we need to have. So as Christy said, the stakes are too high for you not to be contacting an attorney and consulting with this. I can't tell you how many times I've sat in that courtroom, all of them, and the other part, the restrained party didn't appear, and they were granted a permanent restraining order, granted off of like a 3-minute hearing for 5 years. So it's serious, and you just need to take this very seriously.
Thank you, Colleen. Gina, any closing remarks?
No, I think that the attorney said it all, which is that a domestic violence restraining order is a quasi-criminal matter. That means that there are criminal consequences attached to it. Take it seriously. Even if you think the restraining order is going to be granted, seek counsel, because we can mitigate the harm. Even if you don't care about the restraining order being granted, seek counsel, because the consequences of it are so harsh.
Thank you, Gina. And I do want to take this opportunity once more to thank the legal panel for joining and remind the viewers and the listeners that this podcast will be posted on all of our social media websites. And if you have any questions or you have a family law legal issue or a restraining order, domestic violence restraining order issue, please feel free to contact us. You can do it in one of three ways. You can call us directly at 951-587-0505. You can email us at info@temeculadivorce.com, or you can schedule a consultation with us at www.temeculadivorce.com. Thank you guys all again, and God bless.
Thank you. God
Bye.
bless.
Bye.